what's the first step in filing for divorce? So, just to confirm what you're saying, can adultery or abuse influence divorce proceedings?
You just want something else with your life. The court will accept that, and as long as one of you wants the divorce to go through, they will do so.
Welcome back to Law Unpacked. I'm your host, Attorney Sean, and today we're unraveling the complexities of divorce. Whether it's amicable or contested, divorce is one of the most challenging experiences a person can face. We're going to break it all down so you're empowered to navigate this life transition. Let's jump right in. Divorce starts with the decision to file. Let's explore the factors and initial steps involved. What are the legal grounds for divorce in Florida?
So the legal grounds are relatively broad for the state of Florida. The court requires that the marriage be irretrievably broken, which can be a wide variety of things, being that you just want something else with your life. The court will accept that, and as long as one of you wants the divorce to go through, they will do so.
How does Florida's no-fault divorce system work?
So the court's not going to get into the reason that you're separating or filing for the divorce. They don't care about, drug issues or adultery as far as splitting up your assets and debts. Now, they may get into that with you if there are children and when it comes to custody, but they really don't care about it. They just want to hear, here are the assets we have, here are the debts we have, here's how we can divide them.
So, just to confirm what you're saying, can adultery or abuse influence divorce proceedings?
Certainly. So when there is adultery or abuse, the abuse would come more into play if there are children. The court will take that into consideration in its best interest of the child factors. If there's adultery, the court would take that into consideration for any alimony claims, specifically if there was what the court refers to as dissipation of marital assets, which is using marital assets to further an affair, such as if you were traveling or buying extravagant gifts for your paramour.
For those that are just tuning in for the first time, and for those that have watched our first episode in the Family Law series, forgive us as you may hear some of these things again, but we just want to make sure that everybody's on the same page. So tell me, Josh, what's the first step in filing for divorce?
So the first step is having your petition and summons put together, notice of related cases, and if there are children, the UCCJEA. Those will all need to be filed with the court.
So in Florida, is there such thing as an uncontested divorce and a contested divorce? And if so, what's the difference?
There certainly are. If you are truly uncontested, the two of you are on the same page. There also need to be no children. You can have what is called a simplified divorce. With that, you can waive a lot of the requirements of the traditional divorce in the state of Florida, including the financial disclosures, which saves a lot of time and if you have attorneys' money for both sides.
What alternatives in Florida exist for filing divorce? Like maybe legal separation?
There's no legal separation in the state of Florida. You can, however, file for custody and child support while you are still married. However, I will say from all my years of experience, anytime we have done that, the other side will immediately file for the divorce. So it's something we tell you to be expecting should you decide to go that route.
So now that we got the dissolution basics out of the way and how to start the process, let's take a closer look at what happens after the filing. The divorce process can vary depending on whether it's contested or uncontested. Let's break it down. What documents are needed to start a divorce case?
So the divorce case, you'll need your petition for dissolution of marriage. You'll need a summons so that the other side can be served with the paperwork. The UCCJEA if there are any children, and a notice of related cases to let the court know if there are already any custody, dependency, or child support or domestic violence cases open in their district or any other jurisdiction.
Well, tell me, what role does financial disclosure play in divorce cases?
So financial disclosures are mandatory from the state of Florida. You have 45 days to turn them in from the time you are served or from the time the other party is served. The role they play is that both sides have a clear understanding of what each other has. So the assets and debts have to be fully disclosed so that we know everything is being completed when this divorce process is done. There's not another stock that we're missing or a house that was perhaps not disclosed and purchased without the knowledge of the other side.
Which brings me to my next question. How are the marital assets and debts divided in Florida?
So Florida equitably divides the assets and debts. That generally is an even split of all of the marital assets, and those would be assets that were acquired during the marriage.
And I think you're talking about equitable distribution. Is that accurate?
Correct. So equitable distribution is what the court consider a fair separating of all of the assets. It's generally an even split of the marital assets. However, if it's found that one party has dissipated assets, then the court may award a larger portion to the other party.
So we say all this disclosure must take place in the first 45 days. Well, how does Florida handle a hidden or undisclosed asset that maybe they didn't even tell the court that they had or their spouse?
So Florida has recently removed any time frame on going back after undisclosed assets. If an asset's not disclosed in your financial affidavit, there is no time limit to stop the other party. So 20 years down the road, if there is an asset that you didn't disclose and the other side finds out about, they can bring you back to court and request uh, their marital portion of that asset, including likely any interest that it would have accrued from the time of the dissolution.
So oftentimes, and maybe not oftentimes, I think most people know when they're headed for divorce, but sometimes one party doesn't even want to have a divorce. They say, "Let's get back together. Let's try and work this out," but one party's just done and they want to. What happens if one spouse refuses to participate in the case?
If one spouse refuses to participate by not filing their responsive pleadings, then the court will enter a default against them. If they just show up and say, I don't want this divorce, the court will still enter the divorce as long as one party is there to testify that they don't feel that counseling would assist in saving the marriage.
So let's talk about timelines. What's the timeline for finalizing a divorce in Florida?
So there are no hard timelines for finalizing the divorce. The initial timelines you're looking at are, I believe we've gone over the 20 days to file your initial responsive pleading once you're served, and the 45 days for your financial discovery. Beyond that, you're really at the discretion of the courts and the availability of your judges.
So, can a divorce case be settled without even going to court?
It certainly can, yes, either through mediation or the parties working together to come to a resolution outside of mediation. Now, in a divorce, one of you will need to show up for a brief, what we call jurisdictional hearing, but that's just to go over your name, confirm with the court that you are a resident of the state of Florida, and put on the record that the marriage is irretrievably broken and you're asking the court to return you to the status of single and unmarried.
So, oftentimes we've talked a lot about just a couple and the divorce, right? But there's a whole lot more that gets involved besides splitting of assets and debts. It just doesn't affect the couple, it often impacts the entire family. Let's talk about custody and child support next. Child custody and support are critical issues in a divorce. Let's discuss how these are handled in Florida. So, Josh, how does divorce impact child custody arrangements?
So, in the divorce, the court is going to make sure that each parent has a significant time sharing with the children. Granted, that would be appropriate as long as there's no abuse or things of that nature. Some things that you'll definitely want to consider is if you have a marital home, who's getting the marital home? That may impact time with the children if the other party moves out and cannot afford to get a place where they could facilitate having all the children there overnight.
So, let's tell our viewers what is a parenting plan?
So the parenting plan is a detailed outline of what the relationship is going to be like with the child. It goes over, firstly, your time sharing, when each of you is going to physically have the child, but also through a lot of the more minute details that you may not think about, like transportation. Who's responsible for picking the child up, or are we meeting 50-50? Meeting halfway. What communication is going to be like when you don't have the child. Say we have a week on, week off time sharing plan. Monday, Wednesdays, Fridays, we'll generally have calls from 6:30 to 7. All of those kinds of details are going to be in that parenting plan. From communication, transportation, travel with the child out of state, out of country, what that would look like, any notice that you need to give to the other parent. It really is great to make sure that at least the bare minimum is being done by both sides, and that you're on the same page as far as the child goes.
So we've talked about time sharing arrangements, also known as custody, but I think this question is just as important. How does Florida calculate child support during a divorce?
So child support is calculated by the number of overnights each parent has with the child, and then the income of each parent. They are put in, and it gives you out a number. There are, of course, some offsetting factors, like if one of you is paying for health insurance, you get credit for that. If one of you is paying for the daycare, you would get credit for that, and it'd be calculated in.
So tell me, what happens if the parents disagree on custody arrangements?
If you disagree on custody arrangements, you would go before the court, and the court would make a determination on the custody arrangement based on what they consider to be in the best interest of the child.
Well, that brings up my follow-up question. What is in the best interest of the child? Who determines that? How does that determine?
So, Florida has a statute that has a list of factors for what are in the best interest of the child, which include things such as domestic violence, drug abuse. There is who will facilitate and foster a relationship with the other parent, the need for third party intervention, keeping the child on a routine, being involved with their teachers, friends, their social lives, including up to the child's preference.
So let me ask, can uh, so the child can actually come in and testify? Is that am I hearing that right?
On occasions, yes, it is one of the factors. Now, the child testifying is something that would need to be approved by the court. The court would need to make sure that they are mature enough to give that opinion, which they will make their determinations on. Or what we like to do is have a guardian ad litem or social investigator speak to the child and put the preference in a report so that the child doesn't have to come into the actual courtroom.
Well, don't you feel like a child might be influenced by one parent or another when it comes to who they would want to stay with?
Absolutely, and that is one of the benefits of the guardian ad litem or the social investigator is that they can speak to the child privately.
So, assuming once the court sets these custody and time sharing arrangements or time sharing arrangements and child support, are they able to be modified after the divorce?
Yes, the time sharing arrangement can always be modified based on what's in the child's best interest. If that changes in the future, the court will change your time sharing arrangement to meet the needs of the child.
Now, we know that Florida has a lot of transient people, meaning people move to the state, people move out of the state. What happens if a parent moves out of state during a divorce?
To move out of state during the divorce, you would need either consent from the other party or you would need permission from the court to relocate if it's after the case has been filed.
Well, tell me, how can couples avoid the disputes over children in the first case?
One thing we always recommend is either a prenuptial or a postnuptial agreement. Now, those are not entirely enforceable when it comes to the children. The court will need to review that and make sure that what you've agreed to is in the best interest of the child. However, as long as there is no allegations of neglect or abuse, the courts will generally approve the agreement between the parties.
Finally, let's cover what happens as the divorce is finalized. I read a recent statistic that over 80% of cases can be solved through mediation. So, what is the role of mediation in a divorce case?
So, mediation allows both parties to come together to try and work out the resolution without the need for a judge to make that final decision. Generally, the two of you are already doing some type of temporary custody agreement. And if that's working out, this might just be a time to finalize that in a very casual setting without having a judge looking over you and making that determination. You have a lot of freedom in mediation as far as what you're going to have put in your parenting plan, things that you can have done then that the courts wouldn't able to do later.
Well, what happens if mediation fails? What if you can't get to an agreement?
If you can't get to an agreement, then you would set your case for trial and the judge would make that determination.
Well, what if I don't like his determination? Can a divorce decree be appealed? What if I don't agree with it?
It can certainly be appealed. You would need to show that there were some legal inadequacies with what was determined in your case.
So let's assume myself or my partner wants to move on. How does remarriage or cohabitation affect divorce agreements?
So, generally, unless otherwise specified, remarriage or cohabitation will affect alimony for the most part. The only reason it would affect custody is if there were issues with the children or concerns with the children with that new spouse.
Well, we haven't even touched on alimony, but I believe that's coming up in a future episode, so come back and stay tuned. So, moving forward, what happens if someone violates the divorce decree?
If someone violates the divorce decree, you need to file a motion with the court to ask the court to hold that person in contempt and compel them to comply with the decree.
Moving on to retirement accounts, that's always a big issue. How does Florida handle retirement accounts and pensions in a divorce?
So, when at all possible, we avoid splitting retirement accounts. Say one party has one with, for easy math, $50,000 and would owe 25,000 to the other side. If we are going to divide it, we generally do that through what's called a qualified domestic relations order, or what's commonly called a quattro.
So, you're telling me any of my assets that are of my retirement accounts are subject to a divorce proceeding?
That's correct, assuming that the um, retirement account accrued during the marriage.
Well, what happens if I had the retirement account before the marriage?
Then the court would need to determine what was in the account at the time of the marriage and see what accrued during the marriage, and that portion would be marital.
What about pensions? We talked about accounts, and I'm assuming that was more like a 401k account or even uh, or an IRA. But what about pensions? Tell me about pensions. I know we don't have a lot of folks out there with pensions, but we do. We're here in Jacksonville. We see military pensions. We see railroad pensions a lot. I think the post office still has a pension. Talk to us about pensions. How does that how does that play into a divorce?
So, very similar to if there is a 401k retirement account, the courts are going to determine what portion of it is marital and will equitably distribute that between the two parties.
Okay, so we've talked both about what's marital, what's not marital. I want to go back to my previous question. Assuming one party wants to move on, because this is life, you've got to be able to move on after a divorce. If you're getting into another relationship, in the event that you may contemplate marriage in the future, how can you better set yourself up to be protected in the future?
So, a prenuptial agreement is always something that we recommend. It can go ahead and set out how you would divide any assets or debts that you have while you're still in a good place together and not already bickering.
Well, like I said, I think we've covered a good portion of divorce here. We're going to go do a whole episode on alimony because I think that's really important. But that's a wrap. What was as your final thoughts, what advice would you give someone considering divorce?
Definitely speak with an attorney before you begin. You may get some great insight as to what to expect so you can prepare yourself for the process, both legally and perhaps from a mental perspective.
Well, thank you for taking some time today to talk to us on a deep dive into divorce. While the process may seem daunting, remember that knowledge is power. Whether you're just beginning this journey or supporting a loved one going through it, staying informed can make the difference. If you enjoyed this episode, don't forget to leave a review and subscribe for more legal insights. Join us next time as we shift our focus to child custody and how the courts prioritize the best interest of a child. Thanks for tuning in to Law Unpacked. I'm attorney Sean. See you next time.